Hello, everyone, and welcome to today's Fenwick Elliott webinar. My name is Stacey Sinclair, and we are delighted to have so many of you here with us today. Today's session, as you can see, is aptly titled Variations and Delay, Nothing Ever Stays the Same. Clearly a very relevant and timely topic. I mean, time and time again, we hear about construction and energy projects going royally wrong, and delay and variations are two common issues that tend to be at the heart of some of these disputes. And our speakers today are here to help us with these concepts, how to manage them, and how to avoid disputes about them. So we have our Fenwick Elliott partner, Lyndon Smith, and our senior associate, Marc Wilkins, both of which who are very experienced construction and energy lawyers, specializing in dispute resolution, including topics and advising on topics such as variations and delay. Now, just a few admin points before I pass over to our speakers. You will see the questions box in the toolbar at your right. Please do feel free to ask questions as we go, and I will put them anonymously to Lyndon and Marc at the end, time permitting, so do keep them coming in. And rest assured that the recording of this webinar and the slides will be available on our website in due course after this session. And you'll see in the link in the chat box now how you can get to these slides and the recording in due course. So with that, I shall pass over to Lyndon.
Yeah, thanks so much, Stacey. As just touched upon by Stacey there, the reason Marc and I were so keen to do a webinar on variations and delays, because time and time again, we as a firm see parties get into difficulties because of their handling of variations and delay issues. As per the title of our seminar, nothing ever stays the same. And as most of you will know, that is very true of construction projects. What starts out as a well-defined scope of works with a detailed program for the carrying out and completion of works will more often than not encounter changes. And by the time of practical completion, the scope of works carried out may be very different due to variations. And along with that, it's likely to take longer than planned. So in this webinar, Marc and I consider how contractors' works might be varied and or delayed, and how these are provided for in some of the standard forms of construction contracts. We'll also provide some practical tips for avoiding the problems which frequently arise and which all too often lead to disputes. So Marc's going to kick off with variations and then hand back to me in about 20 minutes or so, and I'll cover delays. So Marc, over to you.
Thanks very much, Lyndon. So I'm going to look at variations, and just by way of a brief agenda, I'm going to start off looking at what are variations and why they arise in construction contracts, and then look at some of the limitations on the ability to instruct variations and the payment of for variations. And then I'll look at the procedure for agreeing variations and valuing variations, and then I'll just finish with some practical points for you to consider. So firstly then, what are variations? A construction contract generally involves the contractor agreeing to carry out a specific type and quantity of work, and put simply, a variation is an alteration to that work or the way it's carried out. And when we talk about variations in the context of construction contracts, we're not talking about varying the contract itself, but operating a mechanism under the contract by which changes can be made. And typically variations will take the form of additions, omissions, and changes to the nature and quality of the works. They may also change the or place restrictions on the timing, sequence, or method by which the works are to be performed. So why do variations arise on construction contracts? The particular nature of the construction process make the subject of variations a very important one, and it's simply not possible, particularly on large and complex projects, to foresee every eventuality. And there are a number of reasons why it might be either desirable or necessary to vary the works, whether it be prior to commencement of the project or during the progress of the works. By example, common situations we see are, where contracts may be agreed before the design and the scope of works has been finalised, so changes therefore need to be made during the progress of the works. Inconsistencies or discrepancies which may be discovered within the contract documents. There are instances where it becomes clear that savings need to be made during the construction process. The works may need to adapt to changing requirements of the works, due, for example, to unforeseen physical conditions on site, the unavailability of materials, unplanned changes to the sequence of timing or conduct of the works, or changes in the requirements of the end user. So I've just lost my slides. There we go.
Want me to flick it on, Marc?
I've got them. I think I've got them back now. Yeah.
Yep.
So just to look at some of the limitations on the instruction and payment for variations, there are a number of factors which may limit the ability of an employer to vary the works. For example, there is, the starting point is that there is no general right to vary works under a construction contract. And generally speaking, a contractor who is engaged to carry out works not only has an obligation to complete those works, but also a corresponding right to complete them. And this was a view expressed by His Honour Judge Humphrey Lloyd QC in the case Abbey Developments Limited and PP Brickwork Limited, where he said that a contract for the execution of work confers on the contractor not only the duty to carry out the work, but the corresponding right to be able to complete the work which is contracted to carry out. To take away or to vary the work is an intrusion into and an infringement of that right. So therefore the starting position is that the contractor is to carry out the scope of the work as set out in the contract documents, and without an express provision in the contract, an employer would not be permitted to vary the original scope of works, and the contractor would not be obliged to carry out any more work than is contained in the original scope. As a result, the standard form contracts contain express provisions which deal with the employer's right to vary the works and the contractor's obligation to carry out such varied works, and also setting out how variations are to be instructed and valued and how their impact on the programme is to be taken account of. Such provisions benefit both the employer and the contractor, providing the employer with the flexibility to change the works and the contractor with a route to additional time and money in respect of any such instructed variations. The contractual definition of variations is important. Whilst all standard form contracts refer to the employer's entitlement to instruct variations, there are differences in the way the contracts define and deal with variations, and these differences will determine the extent to which variations may be instructed and also the extent to which the contractor will be entitled to additional time and money in respect of instructed variations. By way of example, the JCT standard building contract defines a variation in clause 5.1 as the alteration or modification of the design, quality or quantity of the works, and this may include additions, omissions or substitution of any work, and also the imposition by the employer of any obligations or restrictions in regard to access, limitation of working space, limitation of working hours, or the execution or completion of the work in a specific order. By contrast to this, the NEC engineering construction contract merely states at clause 14.3 that the project manager may give an instruction to the contractor which changes the works information or a key date. That's the wording in NEC 3, and in NEC 4 it's slightly different. It's changed to the scope or a key date. The definition of the works. This is obviously a key point as well. I mean, whether or not an item is variation will depend largely on the contract documents and how the scope of works are defined. The contractor is often obliged to undertake work that is not expressly referred to in technical documents in the contract, but is considered to be implicit as part of an obligation to build the defined works. And if the original scope of works was drafted very broadly, it may be difficult for a contractor to prove that a specific component of the works was not included in the original scope. Where, for example, a contractor agrees to build a house for a lump sum, and the contract does not precisely define the works, e.g. by way of a detailed schedule of works or a bill of quantities, A contractor may find that it's obliged to provide everything indispensably necessary in order to complete those works. By way of example, in an old case, Williams and Fitzmaurice, 1858 was, the contractor had agreed to build a house which was to be completed and dry and fit for occupation, and to provide the whole of the material necessary for the completion of the work. It was held that, notwithstanding the specification did not mention floorboards, that this did not mean that they were not included with the original contract. Based on the language in the specification, the court considered that it was clear that floorboards were required in order to complete the house, and therefore the contractor was not entitled to a variation to build the floor. Fundamental changes in the nature of the work. This is something we see every now and again, and it can be the cause of issues. For an item of work to be a variation, it must be of such quantity and nature that it would be considered to be associated with the original works. And where an employer instructs additional work which is entirely different to the original scope of works, or is of such a large scope that it changes the nature of the original works, it may be that the instruction falls outside of the ambit of variation provisions under the contract, and it creates an entirely new contract. Omissions of work. Again, every now and again we come across situations where clients have had the remainder of their work removed partway through a project. In some cases because the project is not going ahead, or because the employer has given it to an alternative contractor who's able to offer a more competitive price. There is no general right to omit work from the scope contained within a construction contract, and as His Honour Judge Lloyd QC said in Abbey Developments, a contractor has a right to complete all of the works it was contracted to carry out. Generally speaking, therefore, an employer would not simply be able to omit some or all of the remaining scope of works in order to give it to an alternative contractor. The general view being that if he's entered into a bad bargain, or he thinks he can get a better bargain elsewhere, that's he's effectively stuck with a bargain. That position is generally speaking supported by the courts. And whilst contractors will often include express provisions entitling the employer to vary the scope of the contractor's work in order to adapt to changes in the requirements of the particular project, for an employer to be entitled to omit work, the contract must expressly say so. Even then, the law imposes limitations on the entitlement. Firstly, as to the amount of work which can be omitted, and secondly, as to the ability to redistribute work to others. These issues have been considered in some recent English and Scottish cases, and the current guidance from the court seems to be that a contract for the execution of work confers on the contractor not only a duty to carry out the work, but a corresponding right to complete the work. Clear words are needed if the employer is to be entitled to remove work from the contract in order to have it done by somebody else. And there are circumstances where work may be omitted and given to others, provided the contractual provisions relied upon are wide enough to permit the omission. The general view is that the motive or reason for instructing omissions of the work is irrelevant. There is generally no automatic right to payment. The contractor will often be required to demonstrate that where the alleged extra work was not already included with the contractual works, there is an express or implied right to payment. The employer requested it, or any agent ordered the work was properly authorised, and any condition precedent with regard to payment set out in the contract have been complied with. Most contracts will contain procedures for agreeing variations, and these will often be in relation to the manner in which instructions are to be given, whether they're to be in writing, and if given already, confirmed in writing subsequently. The JCT and NEC contracts contain quite detailed provisions relating to notification and issuing and confirmation of instructions for variations to the works. The NEC in particular adopts quite a strict approach. For example, the engineering construction contract provides that no change to this contract, unless provided for by the conditions of contract, has effect unless it has been agreed, confirmed in writing, and signed by the parties. In terms of valuing variations, where a contract does provide for variations, it will in most cases also contain a mechanism for valuing any variations. The method of valuation will depend on the type of procurement, the form of contract, and the composition of the contract documents. Most standard form contracts provide that where a variation is instructed, the parties are free to agree a price for extra work, or in the absence of such agreement, the variation will be valued using the particular valuation rules contained within the contract. By way of example, under the JCT building contract, the value of any variations is stated it shall be such amount as is agreed by the employer and the contractor, or where not agreed, valued by the surveyor, the quantity surveyor. And this is done in accordance with the valuation rules, which are contained at clauses 5.6 to 5.10. The valuation will be carried out based on the rates and prices in the contract bills, where the work is of a similar character, and where the work is not of a similar character to the work in the contract bills, it will be valued on the basis of fair rates and prices. Alternatively, the contract administrator may ask the contractor to submit a variation quotation when a variation is instructed. Certain contracts have a slightly different system where they have the valuation is based on separate pricing schedules. Such a schedule may operate in one of two ways. It might include prices for additional identified items of work that may be required, or it may provide rates for various defined labour, staff, materials and plant, which may be used to build up the valuation of the additional work. And this is the approach adopted by the NEC forms of contract. For example, the engineering construction contract with option A, which is a lump sum contract, provides that instructed variations to the scope of price using rates which are contained in the shorter schedule of cost components, which is an appended to the contract. That appendix is designed to include, among other things, rates for staff and equipment that have no direct correlation with the lump sum contract price for the original works. So just to finish off, as Linda started off saying, nothing ever stays the same on a construction project. And the key is to manage the change effectively. Just by way of a few brief points, which both employers and contractors might consider to assist them in this process. For employers, ensure that there are appropriate mechanisms to permit variations and to assess the impact they have on time and cost. Ensure all necessary requirements are included, such as variations to be given and confirmed in writing. This is important for both parties, in fact, because the nature of construction work means that there is often constant communication, such as correspondence on the manner of carrying out the works, the provision and explanations of drawings, replies to questions. So it's important for the parties to confirm that a variation has been given and not merely acknowledge or consent to works, particularly where informal documents or correspondence are being relied upon as variations. Try to identify risks and minimise potentials for variations by ensuring as far as possible that uncertainties are eliminated prior to the contract. For contractors, ensure all variations are issued, or in the case of oral instructions, confirmed in writing. Try to agree the impact of variations, including time, cost and consequences for other work before the additional work is undertaken. And ensure you understand and comply with any condition precedent to payment for variations. That brings me to the end. So I'm going to pass over to Lyndon now, who's going to address the issue of delay in construction projects.
Yeah, thank you, Marc. Just moving on slides. Yeah, so in considering delay, I'm going to address the issues as per that slide: time for completion, what is meant by delay, mechanisms for dealing with delay, procedure and notice requirements, analysing delay, obligation to mitigate, and then wrap up with some practical points for you guys to take away. Onto the next slide. Time for completion. Sorry, I've gone 2 slides. I don't know, Leah, if you could just take it back to time for completion. Thank you. Generally, contract will specify the date by which the works are to be commenced and crucially completed. It is common for the contract to require the contractor to proceed regularly and diligently with the works. Where no time is specified for completion and a court has to intervene, will normally imply a term into the contract to the effect that the contractor is to complete the works within a reasonable time. Now, failure by the contractor to complete on time may give rise to the employer being able to claim delayed damages. And from our experience as a firm, delay to completion is one of the most common causes of disputes on construction projects. So what do we mean by delay? The term delay is generally not a defined term in construction contracts, but rather used to describe the situation where the works are affected by events that have a critical impact on the progress of the works. There's also disruption, which is often referred to alongside delay. However, they are two very different beasts. Put simply, disruption occurs where the contractor's regular and economic progress of the work is affected by an event causing work to be carried out less efficiently than it would have been otherwise. Unlike delay, disruption does not necessarily prevent the contractor from completing the works on time. Next slide, critical and non-critical delays. Now, there's an important distinction to be made between the two because not all delays will impact on the completion date. The critical path on a construction program is the combination of the critical activities from the start of a project to completion. A critical delay to the works is a delay to the progress of critical activity which extends the overall project duration and therefore the completion date because it causes delay to subsequent critical activities. It is a necessary component of a contractor's extension of time claim. But I mean, a good example of a critical delay is on a high-rise building. You need the lift shaft before you can do the rest of the building, or even prior to that, you need piling in place. So a delay to one of those would be critical and impact on the overall completion date. A non-critical activity, however, is an activity not necessary to achieving the completion date and will therefore not be on the critical path. Therefore, a delay to a non-critical activity will not delay the completion date. Concurrent delay. Now, in some instances, there may be two or more competing causes of delay, one of which is an employer risk event, and the other event for which the contractor is responsible. So it's a neutral event, and this is what is known as concurrent delay. It's not a defined concept. However, the generally accepted position is that the effects of an employer event and a contractor event must be simultaneous for a delay to be classified as concurrent. And the generally accepted understanding of concurrency, as is put by John Marin, QC of Keating Chambers, and you can see it there on the slide, a period of project overrun which is caused by two or more effective causes of delay which are approximately equal causative potency. Now, the general approach of the English courts to concurrent delay and was set out by Mr. Justice Aikenhead in the Walter Lilly case, 2012. And you can see what he said there in the first quotation on that slide. I'm clearly of the view that where there is an extension of time clause such as that agreed upon in this case, and where delay is caused by two or more effective causes, one of which entitles the contractor to an extension of time as being a relevant event, the contractor is entitled to a full extension of time. However, note that that's with concurrency, it's only the time the contractor gets and they don't get their loss and expense. As with everything in the law, it's never black and white. There are always exceptions. And in the case of North Midland Building, 2017, the extension of time provisions were amended so that where a delay event, which would ordinarily entitle the contractor to an extension of time, was concurrent with a delay event for which the contractor was responsible, the contractor would not be entitled to an EOT. And you can see what the judge said there at the bottom of that slide. But I mean, in short, all that really shows us is that the parties are free to agree whatever they like in terms of how concurrent delay should be dealt with. Looking at mechanisms for dealing with delay. Well, construction contracts will generally provide a mechanism for dealing with delays. It's in both parties' best interest to ensure that the contract provides an adequate mechanism for allocating the risks of delays, enabling the completion date to be extended where appropriate, but dealing with the consequences of delay otherwise. So for the contractor, it provides a means by which the completion date can be extended to take account of delays which are outside of the contractor's control, and provides certainty as to the amount of damages in the event of a culpable delay. For the employer, it protects against time becoming at large. Now, delay events which are likely to entitle a contractor to an extension of time generally fall into one of two categories: delays caused by events for which the employer is responsible, or neutral events. These can be strikes or force majeure. The JCT standard building contract 2016, clause 2.29 lists out relevant events which entitle the contractor to an extension of time, and these include variations, which have just been touched upon by Marc, compliance with instructions, any impediment, prevention or default on the part of the employer or any person acting on behalf of the employer, adverse weather, and also in there can be strikes, lockouts, and again force majeure. However, though, a cause of delay that is not a relevant event will be at the contractor's risk entirely. So a contractor failing to complete on time, where they are not entitled to an extension of time, is a breach of their contract. And the remedies for the employer include the right to claim damages for the contractor, now whether that's liquidated damages or unliquidated general damages, or in certain circumstances, or quite rare, the right to terminate the contract and engage a replacement contractor to carry out the works. Now, looking at the first of those 2 points, damages, general damages will be assessed on the basis of the usual principle that applies to all types of breach, and that is the employer will have to establish that it has suffered loss and that the loss was caused by the contractor's breach. However, and as I'm sure you'll all be aware, more relevant to construction contracts are contractual provisions that allow an employer to recover a fixed sum of money as liquidated damages, and these provisions usually provide for a daily or weekly fixed amount which the contractor will be liable to pay in respect of any period of delay beyond the completion date which is caused by the contractor. The second of those 2 points was termination, which, as I said, was unusual. Where there's a serious delay, there's also the question of whether the employer is entitled to terminate and remove the contractor and engage others. But generally, the employer may only terminate a contract for contractor delay where time is of the essence. However, please bear in mind that the provisions relating to time in construction contracts do not normally make time of the essence. So moving on, procedure and notice requirements. In setting out the procedure for dealing with delay, most contracts provide for notice to be given, and this is absolutely crucial. If there's one thing you take away from today, then it's that of the notice provisions. This will form the first step in the contractual procedure for claiming an extension of time for the contractor. Now, the notice requirements, the nature and timing of the notice that the contractor is required to provide will depend upon the wording of the relevant contract. So JCT 2016 standard form, the obligation requires the notice to be given as per the following, clause 2.271, which you can see on the slide there. The top clause, if and whenever it becomes reasonably apparent that the progress of the works or any section is being or is likely to be delayed, the contractor shall forthwith give written notice of the material circumstances, including the cause and causes of the delay, and shall identify in the notice, etc., etc. So whenever it becomes reasonably apparent, note that in the first line. And then in addition, the contractor is required to provide details of the expected effects of the event or events identified as follows. And that's the second quotation there, the second clause. In respect of each event identified in the notice, the contractor shall, if practicable, in such notice or otherwise in writing, as soon as possible, underline that in your contract, thereafter give particulars of its expected effects, including an estimate of any expected delay in the completion of the works, etc., etc. So as I say, notices, fundamental, get them in, don't delay. As soon as you think you're going to be delayed, get your notice in. Conditions precedent. In many contracts, the service of delay notices is intended to operate as a condition precedent to any entitlement to an extension of time. Now, for the giving of a notice to be considered as a condition precedent, you need two things. One, provide a precise and clear timetable for notification, and two, spell out in clear terms the consequences of failing to comply with that timetable. A failure to comply may deprive the contractor of entitlement to an extension of time, which would otherwise have had in respect of a delay event. So, as I say, crucial that you get those notices in, don't delay. NEC 3 and 4, which I've included on the slide there. And if you look at, I won't read the whole thing, but look at the last paragraph. If the contractor does not notify a compensation event within 8 weeks of becoming aware of the event, the contractor is not entitled to change in the prices, to a change rather in the prices, the completion date or a key date. So within 8 weeks, there's a clear time frame on there by which you need to be getting on with things and whacking that notice in. Analysing delay. In order to establish an entitlement to an EOT, it is necessary to show, for the contractor to show that the relevant event relied upon was likely to, or did in fact, cause actual delay to the progress of the works and thereby the completion date. So the starting point is generally the contractor's as planned program, obviously as it was before the relevant events, before the problems, the delay items arose. Now, the analysis will often look at progress schedules, day worksheets, deliveries, and other site records. And this gathering of information determines which events occurred, how extensive they were, which physical areas of the project were affected, and which elements of the programmed works were impacted. Methodologies for delay analysis. Well, in this day and age, it's various software packages, computer modeling. However, that's only as good as the stuff that's put into it. So record keeping, as you can see, the bottom bullet point of that slide, is fundamental, from the outset of a project. As soon as you know you're on this project, make sure you're keeping those records. And it's important for both, not just the contractor, but the employer as well, to maintain the records of events throughout the project, so that if disputes do arise, the impact of events alleged to have caused delay can be properly analysed. Contractors should maintain an up-to-date program and monitor progress. And this, in principle, places contractors in a better position to accurately establish the cause of delays, and in particular, those that can be attributed to the employer. Whilst generally employers are less likely to maintain up-to-date programs or records to pinpoint delay and the reasons for delay, failing to do so may put them on the back foot. But it's just, you should have something in place at the outset of a project. Don't wait until you're 1-2 weeks into it or halfway through it. Make sure you have a system for your records. The terms of the contract may require the provisions of records. This means that the parties have the right to ask for them. Now, the typical records that expect to see, and these should well be known to you, are progress meeting records, minutes of other meetings, program progress updates, drawings, and any updated, revised drawings, obviously correspondence, things like delays to the works, that should be set out in correspondence, labour allocation sheets, daily work area records, site diaries, quality control inspection sheets, handover records, weather records, and progress photographs. I mean, photographs are always great, but just make sure they're dated, because they can be pretty useless if they don't have the date on them. So, obligation to mitigate delays. A contractor who seeks to establish an entitlement to additional time or money for completion of their works will be under a duty to mitigate. And this will require the contractor to consider how to progress the works to minimize the impact of the delays or costs for which it is not responsible. However, importantly, and this is important, the duty to mitigate does not require the contractor to expend additional costs. There may also be express obligations under the contract to mitigate. For example, JCT Standard Building Contract 2016, which requires the contractor to use their best endeavours to prevent delayed works. Obligations such as best endeavours or all reasonable endeavours are generally regarded as being more onerous than the common law duty to mitigate. So, practical points to consider. The allocation of risk, be aware of where the risk is allocated in the event of a certain delay event occurring, and take appropriate steps to mitigate delays when they occur in order to reduce as far as possible the effects of the event. Notices, parties should take care to understand the mechanism in their contract for dealing with delay. So please, before the project commences, know exactly what you're required to do if there is a delay event. Don't just sign the contract, put it in the drawer and forget about it. It's imperative that you know what you should be doing if there's a delay event, because it'll generally involve a notice. If you don't get it in time, you're likely to miss out. So yes, from the contractor's point of view, must be fully aware of the procedural requirements. From the employer's point of view, it should consider including express wording in the extension of time clause clarifying the consequences of non-compliance. And finally, bottom bullet point there on the slide, good record keeping. Keep records, it's essential. And as I said earlier, do it from the outset. Don't wait until things get difficult. Before a project starts, have a process in place by which your records are kept on that particular project. If everyone has their own laptops, which they will, make sure there's a folder for each of their projects. But good record keeping is absolutely imperative. And that's all I have to say on delay. So I think it's now back to Stacey for any questions.
Yeah, super. Thanks so much, Lyndon and Marc. You really have distilled quite substantially, and clearly and concisely in such a short period of time what can be quite difficult areas of law. So thank you so much. And thank you so much to the audience for really writing in so many fantastic questions. I'm afraid we won't be able to get to all of them, but thank you again for putting them in. And Lyndon and Marc might be able to, the ones we don't get to afterwards, will do their best to get back to you on those. But let me see what I can pick out. Marc, let's go to a variation question that's come in. Are there circumstances in which a contractor would be permitted to refuse to carry out any variations instructed?
You're on mute, Marc.
Oh.
Sorry. Yeah, I think the answer is yes, but I think only in very limited circumstances. For example, the JCT contracts, like the design and build contract, does provide for this. Where an employer's instruction alters or modifies the design of the works, the employer is required to obtain the consent of the contractor. Although the contractor's consent is not to be unreasonably delayed or withheld, so I think it's a fairly limited right. And the contractor does have the right of objection if the employer changes the changes the works such that it affects the obligations or restrictions in the way the work is carried out. For example, access or working hours. Likewise, the standard building contract I think allows a sort of a reasonable right of objection. So they are under the JCT provisions. There are limited opportunities to object, and I think under the NEC as well. I think generally there's an obligation on the contractor to comply with instructions which are in accordance with the contract. I mean that raises the question: what is in accordance with the contract? But typically it would depend on the terms of the works information, I think. But and if you look at the powers of the project manager, he appears to have an unrestricted power to give instructions to change the works information or a key date. But there probably are implied restrictions on that power, particularly where, for example, the work is unrelated to the original scope of work, or where, as we discussed earlier, where the employer seeks to omit all of the remaining work. I think under the NEC, you probably find that your remedy is not to object necessarily to carrying out the work, but rather to invoke the compensation event provisions. But I think, I mean, normally what we find in those situations is that the employer has amended those provisions in the contracts anyway. So you often find that although standard form contracts might provide limited opportunity to object, you'll find that the employers have removed that right from the contract. I hope that answers the question.
Perfect, thank you. Unless Lyndon, you wanted to add anything, that sounds fantastic.
No, that's Marc's done well then. That's fine.
Perfect. We've got a number of questions around delay, Lyndon, so I'm going to pick up on a few of those. One around time being of the essence. Do the provisions relating to time in construction contracts not normally make time of the essence?
Well, that's correct. I mean, normally, it's funny, time of the essence is one of those terms that is regularly sort of used in the construction industry. This time is of the essence on this project. But unless it's specifically referred to in the contract, such as, completion date is, I don't know what to say, 17th of June, and if completion doesn't occur by that date, the employer is entitled to terminate on the 18th, unless it's clearly set out the time is of the essence in the contract. Then it will not impact on the contract. And think about why would an employer necessarily want that in there? Because they've got liquidated damages to fall back on. If the contractor has delayed the works, if it's by a day or a week, the employer doesn't necessarily want to get rid of them and bring in another contractor. They're quite happy for their liquidated damages to kick in, and then for the contractor to pick things up in a week, 2 weeks time, a month's time, when they're ready to go. So that's why we rarely see time of the essence clauses in construction contracts. There are other provisions to allow for delays for the employer, and that's normally liquidated damages.
Perfect, thanks. Getting one further question. Getting to your key takeaway for today, Lyndon, about notice provisions. If someone's going to take away anything from today, let's not forget about these. And we've had a couple of questions around not wanting to upset the client with these notices. Most of my clients do not want to upset their own clients with delay letters, but without them, any claim for EOT loss and expense could fail. What's the best way to get this balance right? And in this case, and several protect a contractor?
Yeah, I think the simple answer is that there isn't a balance. I mean, you've hit the nail on the head there. The amount of clients I can think of over the years who've been contractor clients who've been concerned about putting in a notice because they haven't wanted to rock the boat with the employer early doors. Gosh, I could count numerous, but the simple answer is you have to get your notices in. You know, on Wembley, the contractors started getting their notices in the first week. It's, I don't know if there's a certain tone that you want to put in the letter, but a notice is a notice. If there's a requirement to do it, you have to do it. Otherwise, it'll come back to bite you later on. So I don't think there's a balance to be struck, really. It just has to be done.
Is what it is.
It is what it is, exactly.
Okay, we've got huge amount of questions, but we've come to our allocated time. So again, thank you very much to the audience for putting in those questions, and Lyndon and Marc will do their best to get back to you. So there's only one more thing left for me to do, is to let you know about our webinar in 2 weeks' time. The next one coming up is about the new directions for witness statements. We have Ben Smith of Fenwick, Elliott, and Barrister Sarah Williams of Keating Chambers, and they're going to discuss the new rules on witness statements for litigation in the business and property courts, which is where you would find the technology and construction court. They're going to highlight the practical implications for all of those involved in construction disputes. They're not only going to look at litigation, but also the impact this might have on other forms of dispute resolution, including adjudication and international arbitration. So if you can join us in 2 weeks' time, same place, Thursday at noon. That's our next upcoming webinar, and we hope that we will be able to see you again there. And in the meantime, thank you again, Lyndon and Marc, for speaking today, and thank you very much to our audience for attending, and hope you are well, and please keep safe wherever you might be. Thank you again.